Hello. This week is National Crime Victims' Rights Week. While our work focuses on the rights of victims every day, we speak out this week to remind ourselves and the community how important the role of crime victims and their families are. Listening to the voices of crime victims and survivors is a critical component during all stages of the criminal justice process. It is something the United States government has recognized since President Ronald Reagan created the Task Force on Victims of Crime in 1982, leading to the passage of the Victims of Crime Act in 1984. Following the passage of this act, Louisiana enshrined a Victims' Bill of Rights into our Constitution. This Bill of Rights requires that victims and survivors be advised of all critical court proceedings and allows for victim impact statements during all felony and some misdemeanor sentencing hearings. Here are the highlights of several of the rights that Louisiana guarantees victims of crime, presented by some of the dedicated assistant district attorneys who serve Jefferson Parish.
Oftentimes, people come to us and ask about courtroom seating. Typically, we tell people to sit directly behind the district attorney's table in the office, which is the prosecution. The victims' family, and witnesses are able to sit behind the prosecutors as we try cases, and you watch those cases, which is separate and apart from where defense attorneys and their witnesses sit. So, if ever you have to come to court to testify or even show support for someone you know who's been victim of a crime, please know that in the courtroom, you are able to sit behind us at our desk, which is closest to the jury, the triers of the fact.
The clerk of court is required to provide reasonable notice to the victim or the victim's designated family member. In order for the clerk of court to provide that notice and for the victim to have that right, the victim or the designated family member must fill out a single-page form and file it with either the investigating agency, the prosecuting agency, or the court. Once that's done, the form follows the case throughout its pendency.
Louisiana's victims' rights law has three areas of notification that should be emphasized. First, Louisiana law requires that registered victims and victims' family members must be notified in advance of any parole or probation hearings. Second, pursuant to Louisiana law, these victims and victims' family members have the right to give victim impact statements at these hearings. And the relevant committee or board members must take into consideration the victim impact statement in determining whether or not to release the offender. And finally, third, if an offender is to be released, then the victims and the victim's family members have the right to request that the offender be prohibited from contacting them and even that the offender be prohibited from coming near them.
As a victim of crime, you have the right to seek restitution. If a defendant is found guilty, the court or the Commission on Parole shall require the defendant to make restitution to the appropriate party. If the defendant is participating in a work release program, the defendant shall be required to pay from his earnings restitution. If a victim should need to record a judgment for restitution with the clerk of court, the victim shall not be required to pay the cost to record that judgment. The defendant is responsible for all fees associated with the filing.
Crime victims who are unwittingly thrown into the criminal justice system often feel helpless, as if they have had all power taken from them. Louisiana law aims to give victims this power back by ensuring that their voices are heard throughout the process. To that end, Louisiana law requires prosecutors to meet and consult with victims and their families to obtain their views about how they feel their case should be disposed of, including whether they would prefer that the case be resolved by plea or trial and what they believe a just sentence to be for this crime.